One in the marriage of in the matter of the marriage of von Backstrom. Go ahead with your appearances.
Your Honor, as the petitioner in the divorce, my name is David Minton, and I represent Mr. George von Backstrom.
My name is Kelly Osley Flores, and myself, along with Angie Comer, we represent April Van Backstrom.
Your Honor, as a preliminary matter, you've given us an hour. How did you intend to divide that time?
Equally.
Okay.
Why don't you, is there anything set besides the motion to modify, correct, or reconsider?
No, Your Honor, not that I'm aware of. I do want the court to be mindful of some of my legal eagles have looked at all the time factors and that sort of thing, and pursuant to the Texas rules of civil procedure, I think that we're supposed to have a ruling by 75 days after the judgment is signed, which falls on this coming Sunday. So potentially it is Monday. We filed lots of different things, but the consensus, at least in this firm, is that that probably is still a hard date. So we tried to keep this to a very simple request with the court, and I'm ready to proceed with a very brief opening if the court is ready.
That is fine. You're the movant, so you may proceed.
Thank you, Your Honor. As the court noted, we are here on a motion to modify, correct, reconsider, or reform the judgment that the court has entered in this case. And one of the things that has been sort of a difficult situation for me is when a person has lost a job, as was previously testified to, or the job was completed at the end of March of this year. That was a job that paid Mr. von Backstrom $8,000 a month. John Mankin testified that that was a house that was being built. It was finished, and one of the exhibits that we are going to talk to today is the exhibit that was placed in evidence by both Ms. Osley Flores, which was a proposed support decision by my client in January. There was a previous setting for this case that had the amount of $8,000 in there, plus some additional funds that were later turned over in the court's ruling. There was about $700 a month from an entity. And so those were the resources at that time. This court then admitted into evidence, and we'll see it, I believe our exhibit 38, indicating that at the time of the trial, he was making approximately $3,000 a month in doing odd jobs. We'll get into that in more detail, but very briefly, the conundrum that I have is, what should a person prioritize in the way of money that is owed? Whether that's child support, whether that is spousal maintenance, whether that is a mortgage, whether that is utility bill, what is the priority? And it's important here because if child support or spousal maintenance is not paid, then my client faces an enforcement mechanism, which can include contempt and possible incarceration. As this court is aware, in this final decree, there was one real asset left, and that is the marital residence. My client is in charge of that marital residence in maintaining it, repairing it, paying the mortgage on it, keeping the electricity on and the propane on, and those sorts of things. We are going to demonstrate without a doubt that with the money that he's earned doing odd jobs in the construction industry, that just those 5 or 6 things, excluding food and clothing and anything else other than the school that he is required to pay for this year ending in May of 25, is almost double what his income is. And Mr. Von Backstrom will go through and walk you through all of the money he's made, how he's made it, and what he has been doing in trying to find and get back into a job that pays enough money to pay whatever this court orders in the way of support or maintenance, and in order to get that house sold. And my first questions to my client here shortly are going to be, what is the status of the sale? That's all I had, Your Honor.
All right, Ms. Osley Flores.
Judge, I'll be responding on this matter.
Okay.
Judge, this sounds like Mr. Von Backstrom is attempting to take another bite at the apple. This hearing appears to be more than a motion to modify, correct, reform, or reconsider the judgment. It appears to be more like a motion to modify child support. And I'd like to just briefly procedurally walk the court through what has happened in this case since the judgment.
Your audio just went out. It's very low.
Can you hear me now?
No, not really.
Okay.
I don't know. The volume just dropped.
Can you hear me now?
It's a little bit better. I think
Let me switch microphones.
want to make sure there's nothing blocking your microphone on your computer, or
I
just
don't think so. How about now?
that's much better.
Okay.
Thank
Okay. So, Mr. Von Backstrom, in July, this case was heard in early July. On July 30th, he filed a motion to clarify. On August 26th, he filed requests for findings in child support. The decree was entered on October 8th of 2024. And then after that, he requested findings of fact and conclusions of law. Well, the court entered findings for the child support order, and those findings were very clear in determining whether it was appropriate to apply guidelines or not. The court found that it would be unjust or inappropriate to apply guidelines, and considered 6 different factors and applying 6 different factors when determining the amount that Mr. Von Backstrom would pay. Now, following the findings in child support for the child support order, Mr. Von Backstrom and his original findings of fact, request for findings of fact and conclusions of law, only requested findings of fact and conclusions of law with respect to the property division. He then sought to, after those findings of fact were entered, to have the court amend, or he asked for additional findings of fact, which was denied. So there's been multiple attempts by Mr. Von Backstrom to take another bite at this apple. In neither the period of time where the decree was entered, and I'm sure the court remembers we had a full-blown litigated motion to enter hearing, and then there was subsequent issues. Was there a change to there was never a change to the child support language in the decree reflecting that this was going to be guideline child support. And then subsequent to that, when we were discussing the findings in child support, Mr. Von Backstrom never entered a competing finding. So we are here today on a motion to modify, correct, reconsider, or reform the judgment. And this isn't an evidentiary hearing. This is a hearing to determine whether or not there's an indisputable error in the judgment, whether or not the court misapplied the law at the time, or new law has been entered since the time of the judgment, which is not the case, or whether or not this is so unjust to Mr. Von Backstrom that the court abused its discretion by ordering whatever child support amounts or whatever spousal maintenance amounts were ordered in that previous order. This is not an evidentiary hearing, and I think that they're attempting to reopen the evidence and have another full-blown hearing on this issue. We strongly object to reopening the evidence. The evidence was closed. The court made its ruling. I understand that they're doing this to preserve their ability to appeal. I mean, if we're talking about where the parties are, the parties, both of them, had a ton of debt. The attorneys are owed thousands and thousands of dollars, and we've been going at this since July, and it's December. I just want to correct one thing that Mr. Minton stated. The parties don't have a mortgage per se on the house. They have a pool loan, and I believe that's what he was referencing when he was talking about the mortgage. So, Judge, for those reasons, because this isn't a reopening of the evidence, this isn't a this is a very specific hearing. So for those reasons, we object to reopening the evidence. We object to additional evidence. And we think that the findings that the court made with respect to both the property division and child support are in the record and support the evidence that was heard at trial and the court's judgment.
All right, Mr. Minton.
Yes, a very briefly response, Your Honor, to that is that I absolutely have the right to file what I have filed. I think that I will point out, and I mean no disrespect to this court, in fact, with the evidence that was before the court at the hearing and the proposed support decision upon which the court's ruling regarding the spousal maintenance and child support are not supported by the evidence. The evidence at trial was my client was working odd jobs. He had prepared Exhibit 38 that was entered into evidence at that hearing that showed that he had $3,000 a month in earnings through odd jobs. And if you do the child support calculation on that, then you would have a child support number of $452 and some pennies. And we are asking the court to modify that to what was actually put into evidence. And also, if you were to look at the spousal maintenance award of $2,150, when you have $3,000 in gross earnings at the time of the trial, then the calculation of 20% would be $600 per month. And we are asking the court to make those two corrections to the award of child support and to the award of spousal maintenance. And again, when you do that math, I go back to my opening remark. What do you prioritize when you owe in the way of debts much, much more than that? And what's the priority? What is paid first? And while this is a pool loan or a mortgage, there is a lien on the property. If that $131,000 isn't paid, it's foreclosed on. So my client will testify as to the priorities that he's made. And because there is not the money by any stretch of the imagination, then the mathematics that the court utilized with the evidence at the time, because keep in mind, what you used was the $8,000 per month. That was what we had filed as a proposed support decision in January. His job was completed in March, and that $8,000 a month was gone. And even at $8,000 a month in gross income, Judge, it would only be $1,600 if he was making that kind of money at the time. So the court did err in the mathematics of formulating the child support award based upon the uncontroverted evidence, what my client was making.
May I respond, Your Honor?
Briefly.
My brief response, Your Honor, is I can go into a lot of factual. I know this case very well. My client, she owes us $58,000. Mr. Van Backstrom had separate property. The house is currently listed, and people do not have resources until the house sells. I think things will change once the house sells. But I do not believe that we can reopen the evidence, because then Ms. Van Backstrom would also need to testify about what is existing today. We would have to reopen all of the evidence. And I believe there is no rule of law to reopen evidence. Mr. Minton and I, we can argue back and forth about the facts for probably an hour. It's not going to change anything. I think your ruling is clear. I think the findings of fact and conclusion of law is very clear, and that could have been amended. It was not. So we're asking that you deny the motion. And if they choose to do something further, then they will choose to do something further.
To that one point, Your Honor, I 100% agree. If this court were going to, and I believe the court has the power to correct or reform, let's assume that it does not, which I hope that that's not your position, Your Honor. But the idea that when this house sells, clearly the court could potentially enjoin enforcement until such time as that house sells, and out of his portion can pay the money. Right now, he's looking at an enforcement action that has been filed by the AG's office because he cannot pay the support and the other 4 or 5 very important items. So it's a conundrum that I don't think this court has seen very often, and I darn sure have not. But there is no money, and there wasn't at the time of the court's ruling. So whatever it is that you do, if we are not faced with enforcement, I'm owed $80,000. If we don't have to deal with that, of course, if the court puts the man in jail, then there is no money whatsoever. But Ms. Osley Flores is 100% correct. This changes everything. Both parties are going to walk away with at least Ms. Von Backstrom roughly $300,000 if the house sells at what we stipulated the value is. There have been no offers yet, and that when that's done, we can catch up whatever the court feels like was right. I will point out to their argument mathematical mistakes made by the court. And again, Your Honor, I mean no offense to that, but those are the numbers that were presented to the court as to what he was making and what his bills were. And yes, there is a lot of credit card debt. My client's maxed out, and I assume Ms. Von Backstrom is maxed out. But I can turn quickly to the 2 exhibits that they put in regarding Mr. Von Backstrom's and go back to the testimony about when he lost that job, and it's that clear.
Okay. All right.
I would like to respond to that, Your Honor.
Okay. That's fine. Go ahead.
The evidence is not just the proposed support decisions by both sides. The evidence was a day and a half of testimony involving many other things, including factors that a court can consider on child support and spousal maintenance. The one thing that both lawyers can agree on is that we're owed thousands and thousands of dollars. The other thing that both parties can agree on is that there are no funds at this very moment to pay certain bills. Now, Mr. Van Backstrom, I have no insight into his income since July 1. Don't want insight. The same is true for April Van Backstrom. We have no insight on her income from July 1st forward. The evidence was closed. There is no more argument about what was done. There was a day and a half of testimony about what income was, what each party had access to, and there was back and forth about all of these issues. And so I am arguing that this evidence has been closed. There is a ruling, there is findings of facts and conclusions of law, and they've been signed. And to reopen this, I'm urging you to deny their motion.
Again, when you're looking to correct, which this court has the ability here to do, and if I could, Your Honor, I could demonstrate exactly what I'm talking about from the standpoint of a proposed support decision that he filed where he had a job and was making $8,000 a month. I have a tax return to show what he made in the previous year, which is $96,000, which is 8,000 times 12. And what we presented after that job was lost, and the uncontroverted testimony was that his job at $8,000 a month concluded March 31st of 2024. That is in the record. It is uncontroverted. And not only did he testify to that, his partner testified the house was completed and I'm not building another house. So that's the evidence the court heard on that day and a half, and then made calculations based upon what they put in their proposed disposition of issues. But the exhibits, and if the court,
I have to argue back, Your Honor. Private school tuition came up. These parties have the ability today to take that child out of private school. Private school tuition is not being paid. That child very well may need to be in public school. You talked about it. There are other factors other than just what he's talking about. There are additional factors. Mr. Van Backstrom has the authority to not have his child in private school. That is agreed to.
no, that's a mistake. He was ordered to pay for the 24-25 school year. He has the ability in May. The testimony of both parties was stability for this young man was clearly very important. Changing him midstream was not something either one agreed was in that child's best interest. That's the testimony this court heard in the day and a half you're referring to, Ms. August Flores. Undisputed. One of the few points in which they agreed upon. Let's don't move that kid now. What we asked the court to do back then was, if we pay that, then we shouldn't be paying child support at all. And the court denied that in her discretion. But he's only not paid the last 3 months. And there will be a reason potentially for that he's working with him about potentially building another school. But he owes the money. It's a contract. So I think you got your facts a little bit wrong about what actually was in evidence at the day and a half hearing.
Okay, well, I recall the parties agreed to the private school, in spite of the fact that it's not a decision that seems to make a lot of sense given their overall financial situation. But that's a decision they made. It was not it was a decision brought to the court, in other words, by the parties' agreement.
And that's accurate, Your Honor, but only for that 1 year. I think the court remembers that if he gives notice, he could pull him out in May.
Okay. So I just want to refocus us and make sure we're all on the same page in that we're here only on the motion to modify, correct, or reconsider. And I believe the judgment will either be supported by the record or not. And I do credit the arguments again that we don't need new testimony here today. We're not here on an enforcement. I don't see an enforcement in the file. I don't think one is set or noticed for today, at least. Am I correct on that?
Your Honor, we've been just given notice of the AG's office, so we know that that's potentially coming. We set up the account. There's arrearages of about 16,000. And so we know that's coming, but one of the things we're going to be asking for is the court to reform the amount of the child support and the spousal support to what mathematically was in evidence. And if it does that, then, that reduces the arrearage. He has paid her $1,500 in child support. But there would be a clear from that amount of money. And then, of course, and again, I hate saying these words, Your Honor, but the math's just simply wrong with what the court did here. If the court says, I don't want any new stuff, then let's just go back and let me walk you through the math that was in evidence, uncontroverted.
Now, I disagree, Your Honor. What I would say to you is we have.
They don't want to go there, Judge, because I'm right.
No, I don't agree with that. What I would say to you is there is no motion for enforcement on file today. I know our office is absolutely not filed one. And the AG, they're talking about this man's going to be incarcerated. That is an exaggeration, and we know it.
Of course, but it is a possibility. It goes to the decision making that has got to come into play, that has a community property interest that's ordered to be sold, in which all of these problems go away. If this court were to sit here and say, could you people agree as to whatever number I'm going to change or not change, that's due out of his portion of that sale, we don't need to be here.
First of all, you've never approached me with that. And so I haven't even talked to my client about it.
Can we go briefly to the two exhibits that this court that was in evidence on the day of the hearing, Your Honor?
I'm going to object.
Are these?
It's not new evidence. It's the same evidence that was in.
But I have lots of evidence that I can open back up and for her to review. You want to pick out two pieces of evidence in a day and a half of trial. I object.
I get that, but one you put into evidence and the other I did.
Mr. Minton, are they attached to your motion?
Your Honor, they are in the exhibit list. They are number 4 and 5. 4 was trial exhibit R, meaning Miss Von Backstrom, 02, which was George's proposed support decision from January 22nd, 24, which before this case was continued. The trial exhibit number 5 is petitioner's 38 that was admitted into evidence, which is George's proposed support decision of June 17th, 2 weeks before the trial. And I don't think the court needs the refreshing that John Mangrum testified and my client testified he did not any longer have that $8,000 a month job. I didn't put that in because I think that's clear. That is in my motion to modify, correct, and reconsider, where I have noted the testimony of Mr. Mankin. So, but if you look at those first two exhibits, you will see the conundrum that I'm in. And maybe this court take us off in chambers and say, what about holding off on enforcement with the potential of incarceration? I didn't say he would be. I doubt that he would. But I think the court could suggest to the parties that's a good idea.
Your Honor, my only argument.
That what is a good idea, Mr. Minton?
That whatever it is that you decide, if you decide not to correct or reform anything, I believe there's a math error. I really do. But if you decline to do that, then am I faced with tomorrow or Monday an enforcement when we are doing everything we can do to get that house sold, because that makes everything go away. And that's what's so difficult about this. There's no money to pay this, to pay income taxes, to pay property taxes, the other stuff on this particular residence that's for sale in a market that is horrible in Austin, Texas. And I know that this court has heard from many, many experts and other folks about that situation. This real estate agent was one selected by Ms. von Backstrom, and I think is working her tail off. But we've had 4 showings and no offers.
I'm going to object, Your Honor. And the reason I'm going to object, this is not the time this is not where you do that. There is no motion for enforcement on file, and you don't bring it up at this hearing. I'm going to object to what he's asking about. There is a lot of other credible evidence other than 2 exhibits. And he and we could argue till noon on what, Mr. Minton and I, we could argue to 12 noon on this very issue, because there's other credible evidence in the record about what the ability to pay. You have the authority to go beyond guidelines if you see their ability to pay.
But I don't
The
have to.
house not,
George?
the house not selling is a concern. But this is not the time to address an enforcement and that Mr. Van Backstrom will pay in full what's past due at the time of closing. That is not this hearing. That is a different hearing. That's when there is an enforcement on file. There is not one on file.
No.
All right. Mr. Minton, let me ask you this.
Yes, ma'am.
I've got the exhibits written down that are part of the trial record that you
Yes.
want the court to go back and review before I determine this motion. I've got that. I'm going to do that. I will take the time to do that probably later today, Monday at the latest.
So you've already finished your Christmas shopping?
Yes, I have.
I haven't.
And so I'm going to do that. And I think you've told me why you think those exhibits mean that the judgment is wrong or should be modified, should be corrected. Is there anything else you need to tell me?
What I would have done today, Your Honor, in the way of testimony, because I think it's important for the court to have some understanding of he lost his job and what he's been doing, because there could be, at least in the court's mind, was he getting drunk at night and getting out of bed at noon and not doing anything? The testimony would be is that he has gone to many job interviews in the industry of construction, which is nearly dormant here in Austin, and that he has done the stuff that he can do in order to take on work, which is essentially as a handyman. And because if and when there ever is an enforcement or not, I think a court would be rightfully concerned about what has the man been doing to try to make money, as opposed, and not just make money, but there would be evidence that he's sold items of his personal property, which you don't have to do to pay child support or any of your other obligations. Both of his automobiles are for sale and have been for months. And so I was prepared to put on that evidence to allay the court's concern that I've got a deadbeat dad and a deadbeat ex-husband. But if the court is disinclined to hear any part of that, but the exhibits I have is to show how much money he's made since April 1st, roughly $18,000, and that's it. And maxed out his credit cards, used up the rest of his separate property money, and still has the property taxes on that property, which gives him heartburn. If this thing remains unsold, is the county going to step in? irrespective of an enforcement on this other stuff, does it create an issue as to that? And that's, I don't know the exact number, but I think it's like $9,000, $8,900 or something like that in property tax that's due the end of this month and late if it's not paid by the 31st day of January. Actually, it's due January 31. But this isn't an easy case. It's just not. And I'm not suggesting that Ms. Audley is not making the arguments that she should. But if the court looks at just those two exhibits, court's going to wonder why they put into evidence a proposed support decision that was accurate at the time. And if the court then looks at the other numbers that are important, the note on the house, which I call a mortgage, the electricity bills, the propane bills, and all that, just those 5 or 6 things, health insurance for just the boy and the school and other things, it is more money than he's making. And more money that was in evidence at the time, uncontroverted. There was no finding by this court that he was intentionally underemployed at the time of trial. Never has been.
Your Honor, I'm just going to object to any of his comments that talk about what has happened since July 1. And the reason I am is I know why he's making the argument, but all of the arguments that he just made has to do with enforceability and has to do if we were here on a motion for enforcement. There are many arguments that we have on the other side in regards to what was just shared, but we're not here for that. The parties owe property taxes. They're not due until the end of January. I guarantee you, Travis County is not going to foreclose on a home when it's listed for sale and they're not years behind on property taxes. And so any of those arguments I would object to because it doesn't have anything to do with today.
Okay. Well, your objections are noted for the record. Counsel, I think I understand where both of you are and how you look at the trial record and the judgment. And what I need to do is go through it one more time and study what has been put in front of me. And I will get you a decision by Monday at the latest.
Okay, thank you, Your Honor. I think I heard you, but I just want to be clear. In my exhibit list that I just uploaded, it's P004 and P005 are the two.
Okay, those are the exhibits you pointed me to that were a part of the trial record, but now.
Yes, ma'am. The P004 is their exhibit that they put into evidence that was a prior proposed support decision reflecting the $8,000 a month that he was making. And that was accurate at the time. I mean, they put that document in, but that's our document. That's what we filed with the court. And then the other one is the one that he filed just prior to the trial in early July. July 1, wasn't it, Ms. Lord? I think.
You filed it before we started trial on July 1, so I think it was sometime in June.
Yeah, no, it was June 17th.
Yeah.
Is when we filed it.
And you're asking the court admit P4 and P5 for the purposes of.
Yes, Your Honor.
And I take it, is there an objection to those?
No.
Okay, then they are admitted into the record. Anything?
Well, Your Honor, I would like to put on what if the court is disinterested in what he's been doing to try to get work, then
I think she froze. I don't know if she's frozen on your end.
Yeah. Can you hear us, Your Honor?
Judge.
Okay. Not sure what happened there. I'm hardwired, so shouldn't have lost internet. What did I miss? I think y'all were,
I was asking the court, you've entered those, is the court sustaining their objection to anything, about what he has been doing, looking for work, or how much he's made during that time?
yes.
Okay, so I just need to be clear that the court is telling me I don't get any other evidence other than what was put into testimony at the trial.
I think that's right.
Okay, is that the ruling of the court?
Yes, that is. No evidence about what has happened between now and then.
Okay.
Okay. All right. Well,
Can I have a question? Can I ask a question, David?
Gonna object, Your Honor.
May I have one moment to talk to my client and do this? A lot of stress going on here.
do you want to call him on a cell phone, or do you want a breakout room?
I literally can walk across.
Okay.
And just give me 2 minutes, Your Honor.
Okay, let's do that real quick. We'll wait here.
I'm back, Your Honor. I think the question is not one that the court would entertain, but it was, if anybody has any work for me to do, let me know. So.
And Your Honor, I just want to make sure for the record, it's clear that all of the evidence, including the 2 exhibits that you just admitted, that all of the evidence from trial can be considered by you in making this decision.
Of course.
Okay.
All right. That is noted for the record. You'll hear from me by Monday, okay? I hope y'all have a wonderful holiday. Thank you for your preparation, your professionalism. Best of luck for the new year for all.
Miss Oslet Flores and I can fuss and fuss and fuss, and then we can go have a drink and laugh and giggle. So just so you know, I don't take any offense to her remarks, and I hope she doesn't take any offense to mine. But have a happy holiday and a Merry Christmas to all. Be safe.
All right. Y'all take care. You're excused.
Thank you.
Good afternoon, everyone. Welcome to the 200th District Court. We're here in Epping. And Ms. Escamilla, it's your client's motion, so you may proceed.
Thank you, Your Honor. I'm here representing Tamara Schnarr. She is age 37. She's the mother of a 3-month-old. His name is Elior. He goes by Ori. He is actually 3 months and 8 days old today. My client had Elior. He was born on September 15th of this year. And she was in a relationship with Steve Walford, who's respondent here, and they were living together. She recently moved out of the home that they were living together out around December 15th to get some space. I'm sorry, around the week before December 15th, around that weekend, around December 14th to get some space. On or about December 15th, she had Elior with her. She was staying at an Airbnb. Mr. Walford wanted to see the baby, and she reached an agreement with him that he could see the baby from 2 p.m. to 6 p.m. He had his adult son with him, and so he said he wanted to spend, time with his adult son and his baby. So she agreed to let him have the baby for that time period. She has not seen her baby in a week since last Sunday, and this is a breastfeeding baby. He essentially has kidnapped this baby from her. He has refused to turn the baby over. He has sent a contract to her that he has demanded that she sign, and has really essentially said that until she signs that contract, she cannot have any contact with the baby. He has sent her random text updates, random videos and photos of this kid, but she has not had any contact or seen her baby in real life or held her baby or breastfed this baby. And little Ori has never had formula until this time. We're assuming he's had formula. She was so desperate to see him and worried about him that on Thursday, December 19th, she did drive over and drop off a bottle of her breast milk so that this baby could have some breast milk. But Mr. Walford has refused to let her even hold her baby or see him. Mr. Walford has no legal right to this child. He is not on any legal birth certificate, and he has never been adjudicated the father of this baby. And he is holding this child hostage. She did call the police in an attempt to get self-help before she had to hire me. And the police said that it was a civil matter and she needed a court order. And she is just, we're really, really scared because based on what her relationship was with Mr. Wofford, he's a sovereign citizen. He doesn't believe in governed sovereignty, the government's sovereignty. He doesn't believe really in the healthcare system. And so we have serious concerns, not only about Ori getting regular feeding and eating regularly and getting fed. We have concerns that if Ori, as 3 months old do, gets sick or gets ill, Mr. Wofford will not seek immediate medical care. So we're just asking that the court sign a writ today to return the child to my client, to mom, so that mom can have the baby and resume breastfeeding. And then down the road, we can have a hearing, we can have all of this heard out after Mr. Wofford has taken a genetic test, after Mr. Wofford has been adjudicated the father of his child. Right now, he's not even really the father of the child. And that's all we're asking today, Your Honor.
Okay. All right. Mr. Wofford, you're here representing yourself. You received a copy of the motion today.
Yes, I did. Thank you, Judge.
Let me go ahead and swear you in. Just,
okay, good.
we don't have a record, but I will ask you to raise your right hand. Do you swear or affirm the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
So, yes, I will be representing myself. I actually had counsel prior, but just based on how things went, I felt it would be best for me just to speak as the father of Ori. And so to give you a rundown of what happened, I am the father all the way from ovulation to the birth, cutting the umbilical cord. I actually submitted a petition to adjudicate parentage and then also a temporary restraining order that was filed as I got this, the notice to appear. If you want, I can give you the cause number. And so to essentially give you what's transpired thus far, yes, Tamara and I had been in a relationship for a year, and you know, I was with her every single appointment, midwife appointment through various different midwives, and didn't miss a beat and showed up to absolutely everything. And then her mom came out to help because the delivery was quite rough for Tamara. And then also just to speak to
Mr. Wofford, I don't need the whole recitation of the relationship.
Okay.
I need to know a response to the allegations that are pertinent to this motion. And that is that mom has not seen infant child in over a week.
Yeah.
And that you are refusing to return the child, and the child is being breastfed, and that is not happening because you're refusing to return the child. I need to understand your response to that. I don't need the entire history of your relationship.
Okay, I was just kind of following the other counsel's kind of format. So, but I'm happy to answer those questions. So the reason I decided to keep Ori was because Tamara is planning to leave Germany. Her mom is here. They're both German citizens. They've been making plans for weeks. I have it documented, and I included that in my exhibit of my filings. And so she's a flight risk for the child. I have no intention to hold him. And even the agreements that I sent over were to, hey, I'm like, hey, let's work together to figure out something, because without, like, you're planning to leave the country with our child. And I need some sort of safeguards, not only for Ori's safety, but also my parental rights. And they've been circumvented through the birth certificate when I'm the presumed father. I've been there every single day with him. I've raised 3 boys. I know what he needs. And I do agree that he needs his mom. He needs both of us, but it can't be at the expense of leaving the country. And I've done everything I can to work with Tamara. And no, he's not being fed formula. And but she's also been resisting giving him her milk, because the only reason I don't feel comfortable letting him go because I know he's safe here. And I just did this is the chain of custody agreement for the paternity test that I just did it. And so I'm just asking the court to just give me days to prove this. And then looking at the documentation that I sent in my petition, because I am the father. I always have been the father, and I'm always going to be the father. And I understand that I need time to prove it because they told me it's going to take 2 to 4 days because of the holidays. And so I am doing in what's Ori's best interest as his father to make sure that he remains in the country close to his father and his mother. But I do not, I have evidence that she's ready to leave. Her mom's waiting for them to fly to Germany. And that's the only reason that I don't think visitation is possible, because if he's in Germany, I essentially have no access to him. Since we're unmarried, German law doesn't require visitation without a lengthy legal battle. And that's not to mention me flying back and forth to Germany. And so I feel like I'm in a difficult position. Like, I love my child. You know, like I said, he's my fourth son. I know how to take care of babies. And I want to honor Tamara. I really do. But it's like, if I give her possession, she's going to leave because she can get a German passport and maybe even a US passport based on the birth certificate, even though I haven't seen it. So I'm hearing a couple things. I'm hearing that I'm a father in this petition here. I'm hearing that I'm not the legal father, but like, we want to request child support and other things. And so it's just, it's conflicting. And so it just feels like a difficult spot. And from my heart as a father, you know, I'm asking the court to allow me to prove it to him and give us time for this to have due course and due process.
All right, Mr. Walker, do you have a passport for the child?
I do not.
Have you applied for one?
Yes, but I put a stop to it. I put a stop to everything I could.
How did you do that?
Through the, I forget the initials, but it's like something with a child abduction, something or other. But the passport's essentially on hold right now. Or I don't know if it's canceled, but.
Okay. All right, Ms. Escamilla, if you want to respond.
Yes, Your Honor. My client called the passport office today. The passport is in review right now. So I don't know what he means by putting a hold on it. He has applied for a passport for this child. We have serious concerns that he may go to Bali or another country. My client is German. She mentioned going to Germany over the holidays, not to move, but to go visit family. And Mr. Wofford took this action. He never said, hey, can we have an agreement? She gave this baby to him thinking that he would honor his agreement and see the baby from 2 p.m. to 6 p.m. And he has kept this baby over a week now from its mother. He has refused to let her actually hold or touch this baby. This baby needs to have formula. I just think this is kind of outrageous. I've never been served. We've never received any paperwork that he's claiming that he's filed or that he has. I think he's just trying to bully her into getting this child. And he has the child now. He's admitted to applying for a passport. If you'd like to take some testimony from my client about the passport issue, she can testify about what she heard from the passport office today. We have serious concerns about what his plans are.
Okay. All right, Ms. Schnarr, if you would raise your right hand. Do you swear or affirm your testimony in this cause will be the truth, the whole truth, and nothing but the truth? I didn't hear the answer.
Yes.
Okay, go ahead.
Thank you.
I guess, Ms. Escamilla, do you want to ask her questions or do you want me to handle?
I'll let you handle it, Judge, unless you prefer I do. I'm happy.
Okay, no, that's fine. Ms. Schnarr, I guess my first question is, have you applied for a passport for the child?
I did not, I haven't applied.
Okay,
I,
and what do you know about Mr. Wolford's application?
I remember we went together. It was, I think, December 10th. And it was really urgent and important for him that we go during the time that my mom was here. And things were already getting challenging between us. And so basically, we showed up at the office, at the passport office. I was taking care of Ori. I wasn't fully present. I didn't even see what he gave the people there, the officer, what are they called? The agents to apply for the passport. I remember I did afterwards. I informed myself, and I know that I signed the DS-11, which back then I didn't know because Ori was fussy. I was taking care of him. I even asked the person, the agent that was serving us, if I could go away into a cubicle and breastfeed him. And I wasn't even aware that Steve used his birth certificate that he created himself and stamped by the notary plus an affidavit to basically not having to use an official birth certificate. And as I found out afterwards too, the passport was in his care only without my knowing. So he indicated all of his contact information and was only in his care, not in mine.
Okay. And you don't have any plans to move to Germany?
From the beginning, I suggested that I take time away. A lot has been happening in our relationship. The pregnancy, birth, postpartum, it has really taken a toll on me. I haven't gotten the support that I needed to suddenly be a mother and having full responsibility over a human being. And I always kept asking Steve for more support, which I didn't receive from him. And then once my mom came here, I just felt what it's like to receive support. General support. I can go more into detail, but that basically brought up the idea of, wow, it would really feel nice to actually be with my family, be back home in Germany, introduce Ori to my family, and really also recharge from a challenging time this year.
Okay. Ms. Escamilla, anything else?
Yes, if I may, Your Honor.
Okay, briefly.
You got it. Ms. Schnarr, you are a permanent resident of the U.S., correct?
I am.
And you've been a permanent resident how long?
8 years.
Since 2016, is that correct?
Correct.
And you don't have plans to move to Germany at this time, right?
Steve knows that I'm actually aspiring to get American citizenship.
Okay. Just so the court is clear, it's a simple yes or no, okay? Just so the court is clear, when you were talking about Germany, you were talking about going to visit your family for the holidays, just for a visit, correct?
Correct.
Okay. And then I think that's it. I think nothing further, Your Honor.
Okay. All right. Anything else, Mr. Wolford? About as it relates to the child and the current situation?
Yes. And do you mind if I address a few of these points that were brought up just for clarity?
If you do so briefly.
Okay. So I'm planning on staying in Austin tomorrow, and I were wanted to move to Bali and live abroad. I had no intention. The last thing I want to do is drag a child around the world. And so the intention is to just stay here unless sometime in the future, Tamara and I decide what's best for him and everyone involved. Also, I want to mention that, I did take possession of Ori for the last 10 days or so. Prior to that, Tamara actually hid her location from me and wouldn't allow me to see him. I did see him for about 30 minutes in that 30 days, but she essentially withheld him from me. And like I said, in some ways I did do the same thing, but it's again because of this flight risk. And when I talked to Tamara, there was like, I just need to get a way to recharge. There's no definitive date. And I know what happens when she's there. If she decides to stay there, like there's zero recourse for me. And that's the biggest thing, is that I need to be in his life because I know what's in best interest of Ori. And I want to do everything I can do to work with Tamara so that way we can provide for him the very best way possible. And I agree that she needed support and I did everything I could, but while, I'm taking care of her a lot, which was like almost a full-time job, taking care of the baby and then also working to provide. And so, and I understand that Germany might be an attractive way in a lot of options, but in my view, that's quite risky for me because she could literally just say, I'm not coming back. And unless there was some sort of custody arrangement in Germany, and that's way beyond my scope of knowledge. And I'm not, I want stability for Ori. Like I'm really doing this. I want him to have a stable life and not traveling all over the place. And it's about what's in the best interest for him. And I'm hoping the court can help remedy that.
Okay, well, what is best and what is stable for an infant is to be seeing his mother on a daily basis, especially when he is a nursing child. So, you can agree to return the child by 3 o'clock this afternoon, or I will issue the writ. That was to you, Mr. Wofford. Do you have a response?
Yeah, what recourse is there that I get him back, and what recourse do we have? Like I'm open to having a visitation schedule, and I'm open to like having some sort of safeguard that like he's not going to leave the country.
Okay, well, I will address a couple of things on the passport because both parties have raised issues. So I am going to enter an order that if either parent obtains a passport, it will be surrendered to the 200th District Court of Travis County. Okay. If either of you receive a passport back from the State Department, it is ordered to be turned over to this court until these issues receive a further hearing. Whether in this case that Ms. Schnarr has filed or the case that Mr. Wofford says he's filed, I further will order that no one may leave the country with the child, period. So that takes care of what both of you are saying on the flight risk. And I do appreciate that. Bali, I don't believe is a member of the Hague Convention. I think Germany is. But in any case, it is very difficult and very expensive to return a child to the United States if they are taken by a parent who's unwilling to return them. However, I'm still faced with the immediate problem of a mother who is being deprived of a child that she is nursing. And you are welcome, Mr. Wofford, to get on the phone with Ms. Escamilla, either you or your lawyer, and attempt to work out a temporary visitation schedule. I can't do that here because I'm handling all the emergencies for the entire county, and there are others coming in as we speak. So I'm very limited on time. But first, I think you need to confer with her and see what can be worked out. I fear based on your actions, there's going to be some hesitation to work with you. but she knows her client and the facts and circumstances of the case. And she knows that in a week or two, there will, in all likelihood, be a temporary orders hearing. And she knows what a judge is likely to do at that hearing. So it might make sense to get that worked out by agreement in advance. But I can't impose it upon you. So I ask again, Mr. Wofford, after having made the rulings about the passport, prohibiting both parties from taking the child outside of the United States, will you agree to return the child today by 3 p.m. to Ms. Schnarr?
Yeah, is that so essentially I give Ori back to his mom by 3. Actually, can you make it more like 5?
No.
No?
If you don't agree to 3, I'm going to send law enforcement to come and get him. That's the alternative.
Okay. Yeah.
And I don't like the alternative. Let me be very clear. I am reluctant to get law enforcement involved. However, I need you to understand what you've done is not okay. It's not okay. It's not in the child's best interest. And under the law, you currently don't have any parental rights. You're not married, so there is no presumption of anything regarding you. You are not the presumed father. And
Okay.
if you were married, that would be different, but you're not.
Mhm.
And that's just the law, Mr. Wofford. I don't make the law, but I follow it every day. That's what I'm here to do. So you can agree to 3 o'clock. If you don't, I'll sign the writ and law enforcement will come and retrieve him. If that is, you need to stop and think for a moment. Is that really something you want to inject into your child's life?
Yeah,
Is
of
that
course
really
not.
best?
Yeah, I'm not disputing that. Like I said, I have no problem giving Tamara Ori. It was my biggest concern was that she's leaving. And since you put an order to stop that, I have all the faith and confidence that will be upheld.
Okay. Then let me just clarify so I'm clear. You do agree to return Ori by 3 o'clock today to Ms. Schnarr?
Yeah, is she gonna come pick him up?
Ms. Escamilla, is that okay?
I think so. Ms. Schnarr, if I may ask, Your Honor, are you available to pick up the child today by 3 at his home?
I prefer a neutral location.
It's fine. Is there something nearby, like
A public location like a HEB or a police department, fire station? Sorry, Judge.
Sure, libraries are good, fast food restaurants, some people like.
Ms. Schnarr, is there a location nearby that you guys could exchange at near his residence?
I'm looking. I'm finding 888 Pan Asian restaurant on like just looking quickly. It might not be the best, but it's a clear one.
Is there like a 888 Pan Asian restaurant? That's what you found? Let me
Yeah,
see.
it should be close to his
Oh,
home.
on Ontropolis Road?
How about, can I make a suggestion?
That's fine. You're welcome to offer.
There's the Walgreens that's down the street. I believe you know where that's at tomorrow.
Do you have a street name, Mr. Wofford?
So that would be the Walgreens on Riverside. Here, let me get the actual address.
Is it Riverside and Pleasant Valley?
Possibly. Give me 2 seconds.
All right, Ms. Starr, will that work for you?
The location works.
Okay, great. Ms. Escamilla, any other details we need to cover here?
Yes, Your Honor. I guess the understanding is that Mr. Wofford has agreed to return the child to her by 3 o'clock today at 1920 East Riverside Drive at the Walgreens in a public location, and the parties will exchange inside the Walgreens. Is that correct?
Yes.
Okay.
Oh, we need to go inside? Okay.
I mean, Ms. Escamilla, is that your request? Generally, that is better than the parking lot.
I agree. I would prefer that at least it's in then it's in a public location and there are people around. So yes, I would prefer that. And then if he does not sign, if he is not there by 3 p.m. with the child, Your Honor, then we will submit this writ and ask you to sign it if that's okay.
Yes.
Okay.
If I hear back from Ms. Escamilla that the exchange did not occur at 3 p.m. and I'm saying 3:05, she can let me know it didn't happen. The writ will issue and we'll get law enforcement involved. I don't think that's good for anyone. And I'm glad that Mr. Walford, you've agreed to go ahead and return him. And then what I encourage you to do, you have Miss Escamilla's contact information. You need to reach out to her and talk about what you raised as far as visitation and getting temporary orders in place until y'all can have a further hearing on all of the issues that have been raised. Okay?
And I'm happy to talk to Mr. Wofford's attorney about that if he wants to pass
Yeah.
the information.
Mr. Wofford, if you have an attorney, you can have him or her.
For this, I prefer to handle my own affairs.
That's up to you.
Yeah.
All right. Okay. Well, just a reminder, if anyone receives a passport for the child from the State Department, it is to be surrendered immediately to the 200th District Court at 1700 Guadalupe, 9th floor. And both parties are enjoined from leaving the United States with the child until further order of the court after an evidentiary hearing. Okay. All right. I encourage you to talk and try and work out the other issues, but for now, I see an agreement to return the child by 3. If not, the writ will be issued. All right.
Thank you, Your Honor. May we be excused?
Yes. Best of luck to the parties. I hope you're able to get on better terms as the new year arrives. Best to you both.
I do
Take care.
too. Thank you, Judge.